17,
2017.
which was forwarded for the court to lift the temporary order of or have an acre of the suit property, as well as an order for inhibition. The defendant opposed the application. Question whether it is within the mandate or jurisdiction of the Environment and Land Court to deal with historical land injustice claims, and held that the above passage, which I have, in the case of Chief Land Registrar and 4 others, which I have just quoted, the Court of Appeal in the above case held that the Environment and Land Court was right in holding that it has jurisdiction over the matter. It can be noted from the above decision of the Court of Appeal, which is binding on me, that inasmuch as the National Land Commission has a mandate to look into historical injustices, an individual can still commence a constitutional petition on a foundation of historical land injustice. It is therefore my finding that this court has jurisdiction over the petition herein, and I decline to defer jurisdiction to the National Land Commission. Whereas the petitioners may have valid complaints against the respondents, such cannot be prosecuted in an omnibus style. It is imperative that pleadings are drafted with certain degree of clarity and specificity as to accord a respondent a fair opportunity to know what the complaint is all about and to possibly prefer a response thereto. Given the nature of the petition and the gravity of the issues raised, there remains the need that the pleading be crafted in such a manner as to demonstrate how each respondent violated which of the petitioner's constitutional rights. It is therefore my finding that the petition does not meet the threshold for constitutional petitions established in the Narita case, which I have referred to, and must fail. The petitioners, in my view, will not suffer any prejudice, as they can still pursue their application already lodged with the National Land Commission, the 21st respondent hearing. In the result, I find that the objection raised is merited to the extent that the petitioners have failed to plead with precision the constitutional violations, the particulars of their complaints against the respondents, and the manner in which the Constitution has been violated in relation to their complaints, and therefore has not met the threshold established in the case that I have referred to. Consequently, the petition is hereby struck out with costs to the 1st, 2nd, 3rd, 8th, 9th, 10, 11, 12, 14, 13, 14, 15, and 16 respondents.